welcome everyone. And for those who have requested to share the video and audio, I have not accepted because this is only for the speakers and the moderator. So you get a chance to view and listen to them. Unfortunately, you won't be able to share your video and mic with the rest of the participants. So for day one, the first panel discussion, the topic is on litigation funding for IP enforcement and monetization. So for this session, we have our moderator, Karthik Kumar. He's the partner at Finnegan, Henderson, Farabow, Garrett, and Deminor, LLP USA. And our two eminent speakers are Rose James. She is the Senior Director of Intellectual Property Global at Expedia Group USA. And we also have Michael Watson, who is the Senior Legal Counsel at Deminor USA. Now, Karthik, I'll hand over this session to you and we can carry on with the panel discussion.
Great.
Thank you.
Thank you so much, Chirag. And I'm pretty sure I'm speaking for Michael and Rose when I say we would love to see everybody else as well on video, but perhaps another time. So the topic for our panel today is litigation funding for IP enforcement and monetization. And I'm very happy to report that as we discussed this topic ahead of time, that we had very different perspectives and views on the scope of that topic and what we would cover. And I'm also very happy to have both Rose and Michael with their different backgrounds come in and offer completely different perspectives on the topic. So in effect, I thought what I would do is start with Rose and view things from her perspective, and then switch over to Michael and then interview him for a little while. In any of this, if there are questions that you all have for either the panelists or for myself, please put them in the chat. I'd be happy to address them. Or otherwise, if you're able to submit your question another way, please do so. And I'd love to hear from you. So with that, Rose, I'd like to start with you because, I always noticed at these conferences, folks love to hear from in-house counsel. Obviously, Expedia is a name that needs no introduction. And with your title as Global Senior Director, you certainly have keen insight into how things operate at Expedia. So I want to maybe start by having you introduce yourself, what your practice is like, what your day-to-day is like.
Yeah. All right. Thank you, Karthik. I'm so excited to be here. And I will certainly share what I do at Expedia. But I have a long history of heading intellectual property teams and sort of what I'm doing at Expedia. I'm pretty new at it. It's about 6 months in the job, but I've had many years of doing similar work. So as the head of the intellectual property team at Expedia, we have a team of about four people, a director level attorney, and we have 2 paralegals. And we're responsible across the board for all of the intellectual property issues. So traditionally you have a patent practice and a trademark. So we're e-commerce company. So a technology company for travel. And so we have heavy issues related to advertising, and we just support that. We have a separate advertising law team, but we support them on all of the trademarks and brand related issues, content licensing, and a lot of domain name enforcement, and also acquisition and managing domain names, ensuring that we have traffic going to properties or to, so we can have bookings. That is essentially what we're trying to get people to pretty much register for the, make your reservations and go on travel and see the world and have wonderful experiences. So, and then there's a large section that is software related. So just developing software, using third-party software, open source APIs. So a lot of those kind of issues. So it's a really diverse and broad practice of law. And we have of course, outside counsel that supports us on that. We have a couple of law firms that support us on the trademark and domain name work, and 2 others that support us on our patent portfolio. But generally, that's it. We're there to strategically help the leaders accomplish their mission and their goals by facilitating the intellectual property issues.
That's great. It sounds like your team is super busy then, as you're going through the list. So a question for you in terms of Expedia's outlook and the outlook of the other firms that you've been a part of in the past. Can you summarize sort of at a high level what their philosophy is, generally speaking, when it comes to IP enforcement and monetization?
I would say Expedia is, it's a company that is not new. So it's about, spun out of Microsoft about a little bit over 20 years ago. So you have to always put that in context when you think about their portfolio, the IP sort of strategies and stance and how things are happening. So, and it's a company that's also really pivoting from having multiple brands of that they support to sort of shifting to one platform for the various brands. So there's a lot happening that is causing there to be a focus on intellectual property and patent rights in particular. So, but before that time, we have a pretty robust program sort of in place, infrastructure created for all type branding. So trademarks and the clearance and acquisition of domain names, all those things. We have and as a service provider, because we have a platform that other companies use and that's used for travel. And so we have to have the process in place for takedowns, not, for if anybody sees their intellectual property being used on our site, that we have to have the process for the copyright takedowns, trademark takedowns. So we have a really strong infrastructure for that. We're currently building a formalized program for our patents, the patent program. We don't have a patent review committee right now, but we're putting one in place. So I would say Expedia's philosophy had been really protecting the brand and making sure that they work these the different hotels.com, VRBO, Verbo, Travelocity, Orbit, all of those different brands that people don't associate with Expedia, all part of the Expedia group. And so moving away from the separate brands to coming together, having one platform, one loyalty program across all of the brands. So I'd say the philosophy now is ensuring that we have put in place the protections to move in the direction the company wants to move.
That's great. And it's, as I hear you speak, it's so patently clear how important IP and IP enforcement is to the business as a whole, right? They're so intimately integrated to each other that I expect that for most cases, the business folks and the IP folks are very well aligned in terms of enforcement priorities. Can you comment on that a little bit?
Yes, we definitely are. So we have internally an IP aliases that we use so that the business, when they see infringement occurring, that they will report it to the IP team and we can take action. We also work sort of partnering with our cyber team. So in this space, as a service provider, when you have properties and whatever, there are lots of fraud that occurs, and people put up domain names and put the Expedia hotels or any of those brands in their domain name to sort of get people to do things. Or you think that you've gone to a website where you're, Expedia, where you're booking your air travel or your hotel, and it's not related to us, and someone has taken your money. So we have a system, a process that we build in place where if something comes to the threat team, it's a cyber related issue that's also fraud related, that we work together. We handle the IP enforcement part of it, the domain name issues. We do UDRP proceedings. We do other enforcement. We try to do the takedowns of some of these domain names. And so we work we're very well coordinated with the business and the different parts of the business that work with the intellectual property team and all of the other parts of our legal team. So it's not just IP. Like I said, we taught, privacy team. We work closely with them. We work closely with the purchasing attorneys and the ad law, where we're like hand in hand all the time. So we're very collaborative at Expedia, and it comes through in how the business work with us and how we work together in the legal team.
Okay. Now, when it comes to organizing funds and budgets for enforcement and monetization, can you talk at a high level of what the overall process is for deciding what the enforcement priorities are and how much budget gets allocated to different things? Can you talk about sort of the planning aspect of things?
That's a really good question about budget, because anyone in-house knows intellectual property, particularly a patent portfolio, is very expensive to prosecute, to have invention disclosures reviewed, to have them determine you'll file an application, and filing all over globally. When you're a global company and you have to do this filing, it's expensive. It's like $25,000 dollars per application when you think about it. So in most places, including Expedia, what we've wanted to do is to make sure that the business that's responsible, where the technology is coming out of, they would pay for that cost. And in Expedia, lucky for us, we have an extraordinarily engaged CTO and a CTO's team. Her senior level team all have experience with intellectual property, and they're very interested to know. And so with that interest, it has pushed us to being able to get a budget from the CTO for our patent program, which includes inventor incentive. Of course, we want to have an internal docketing system, an IP portfolio management system, where to have an inventor portal that may allow us to do prior art searches. So all that stuff is costly. So we put together a budget, me with a partner that been identified for me, and a distinguished engineer within the CTO's office. We developed a budget, we made a request, and it was granted. So we actually do have a budget that is identified for the things that we want to do in year one while we're formalizing our patent program. So generally, it's split between the legal team pays some of this out of their budget, and then the businesses where the technology come from, or if you have an entity like the CTO's office that houses the patent program, it could come out of their budget also. That's usually how it works.
Okay. I did want to ask you for your personal views on a topic, and I'm sure as you look at different firms, even the firms that you've worked with, there are probably different ways in which people handle the issue of how to allocate budgets for different priorities. So I can imagine on one end of the spectrum, the IP department is given an overall budget and given carte blanche to sort of figure out how to spend it on the priorities, and sort of given some level of autonomy in making those decisions. And then on the other end of the spectrum, I can imagine a situation where every individual enforcement decision or monetization decision is one that gets approved by the specific business unit, and then budgets allocated sort of on a case-by-case basis. As you consider the spectrum of possibilities for how businesses could organize themselves and plan for enforcement of their IP, where do you personally think the line should be drawn between providing autonomy to an IP department versus having micromanagement by the business unit in terms of getting the best outcomes for that business?
Yeah, it's an interesting question, and I should have started by saying my views are my own. I'm not representing Expedia, and all of the views I can share based on my experience and knowledge, but these are my views. I actually do like the way Expedia is sort of does the balance. So I talked about the fact that we have to have a budget. You have to know, and how much money, what the funds that you have available, so that you can prioritize. And so from my perspective, the way that we do it in terms of, and that I enjoy, because it gives me a great level of autonomy to be able to make the decisions based on the strategic position of our technology. So a CTO says, these are things we care about, these are the things that we're externalizing, these are the products that we're doing. I will make sure that, you know, the money that we have available, we spend it on these things. There isn't any sort of oversight of how we spend the money, but there's approval of, you know, my boss does have to approve the invoices, you know, from external counsel. So he will be like, oh, how much money did you spend on this, you know? So, but I do not have to go and request for permission to make those decisions. So high level of autonomy, I think that works, but you have to work within a budget, work within the, you know, what is your strategic goal that you are trying to accomplish. I am definitely open to, you know, to creative ways, because I think I'm a creative thinker, creative ways to be able to accomplish these, the purpose, you know, trying to support the business. And it is, you know, IP is one of these things that, you know, when you're doing patents and whatever, people, you know, it's not a return, you're not selling a product, you know, what are we getting out of all of this money that we spend? And it's so costly that it would be, if we have alternative ways to consider how we fund it, I think I'm very open to that kind of discussion, or at least learning more about it.
Great. And I do want to ask you one last question before I introduce our next guest here, which is, as you look at your plans, you're sort of fairly, you know, new at Expedia, but you've got a vision for how you want things to go. Can you share, you know, for those who are trying to embark on a journey of developing a portfolio of assets, a diverse portfolio of IP assets, and then planning forward a vision for how that can be a core asset of the company. Can you give us any thoughts on how folks should think about creating a vision for their firms, and what elements go into sort of bringing people together in the way necessary to enforce and monetize IP? Because as we all know, without that backing, your IP doesn't really mean much in terms of value.
Exactly. Absolutely. The first is education, right? People have to understand how intellectual property is part of what they do, and how it relates to their everyday work, how it relates to what they're trying to accomplish, and what does it mean? You know, the sort of hurdles, like we need to get a license. What happens if you do not have appropriate license rights? What happens if, you know, we violate somebody's rights? What happens when we've created something that you haven't protected, and now someone else can go forth, because, you know, first to file. So, and then it's up to you to sort of how to disprove that. So it's really raising the awareness. In my entire experience, when I first started really managing a team in IP, the first thing that we did was education, and spent a lot of time raising the awareness of leadership, of the people, so they can understand what their roles are, what it means, and how it helps them ultimately, because we're not here to stop, you know, to prevent, to get in the way. We're really here to help. So once you have that, and you get people, and then you get that buy-in, and they understand, or you could have examples, because I always have the examples where things went wrong. And we show that see that we had this great idea, and we have it as part of a product that we're selling. We want to monetize it, and you're like, is this protected? And I'm like, well, no, because you didn't disclose it to us, and you included it in an invoice to be to a customer. So right now we are barred from pretty much doing anything. And it was something that's critical, important to that particular business. So then those kind of experiences, when you explain to them the consequence of it, it's essentially just getting buy-in, getting people to understand. And then once you've done that, you've gone 85% of the way to being able to make some inroads.
Great. Well, thank you so much, Rose. I absolutely enjoyed every moment of what you were saying. And to to piggyback on a point you made about being creative, I want to introduce our next panelist. And as you listen to his creative ideas for litigation funding, you'll also notice that this panel had completely divergent views on what this topic meant, meaning that we were being pretty creative in interpreting this topic. So with that, Michael, I wanted to introduce you and Deminor. Maybe could we start with introducing what Deminor does and the idea of third-party litigation funding? Because it's a completely different topic if you think about it from what we've been discussing with Rose so far.
Yeah, absolutely. So Deminor is a litigation funder. That's, and again, I'm sorry for my hoarse voice. It's especially if it makes me hard to understand. But yes, so we are a litigation funder. Where it's a Belgian-based company, but operates throughout the world, including in the U.S. And we work primarily or essentially exclusively with plaintiffs who want to bring litigation to enforce their patents, but don't have sufficient funding to cover the lawyers' fees or costs. So or we can work with law firms who are working on contingency and want to mitigate their risk. So for example, if you are a small or mid-sized startup and a large player is violating your patent, and I'm using very round numbers, but you imagine that you have $100 million in damages, but unfortunately the party that's violating your patent is very well funded, and you're not, and you're thinking I need budget of up to say $6-7 million to litigate this, even though I know I'm very confident I can get 100 million if I can succeed. I don't have the 6 or 7 million to get there, and that's where Deminor comes in. And so essentially what we do is we cover those costs. We're essentially converting a situation where your ideal law firm, the law firm that you want to use, does not want to work on a contingency, but you don't have the money to cover their fees. We're converting that into a contingency situation. So we're paying their costs, and then we're taking a cut of the damages. It's non-recourse funding. So if the lawsuit is not successful, then Deminor eats the loss, not the litigant.
What's really interesting about this topic is I think litigators within law firms have started to hear a lot more from venture capital types or hedge fund type folks about how there's so much money on the sidelines waiting to invest in a litigation, essentially. But it's not a topic that you typically see outside of those sort of those specific contexts. So can you talk about what exactly the business model is from your perspective with Deminor in terms of investing in a litigation? How do you assess a litigation as an investment opportunity for yourself?
Yeah, sure. And just to be clear, Deminor is not a venture capital fund or a hedge fund. We're a dedicated litigation funder. So we don't do other things. There are hedge funds that have little arms that are active in this space, but there are also dedicated litigation funders, including large ones now, publicly traded litigation funding companies. That's what they do. And that's, I think if over the last 2 or 3 years, the awareness of litigation funding as a distinct asset class is growing. And, I think if 2 or 3 years ago, most litigators, even litigators who would hear about this before inventors, before claimants, really were not familiar with litigation funding. I think we've reached the stage where most people have heard of it. They know it's out there, but they really don't know a lot about it. They don't know how it works. They don't know how the ecosystem works at all. So now that I've clarified that we are a litigation funder and not a venture capitalist or hedge fund, the question I think was how we assess litigation. It won't surprise you. There's kind of three kind of avenues that you have to look at. That you need to look at the merits of the case, which most people on this session probably know as well or better than me. You're looking at validity, infringement, and if you go down the validity path, again, it's nothing that everyone on this call knows this better than I do. You've got to look at prior art and show that it's novel, and you've got to look at, you want to make sure it's non-obvious. If it's software, you've got your Alice risks. All of this is, I think, everyone's bread and butter. But we're all attorneys at Deminor, or nearly all attorneys. We're not a law firm, we're a funder, but everyone practiced law for many years before coming to Deminor. We do a lot of that in-house, and then we also have outside counsel that we use for secondary due diligence. So I said merits was one avenue. The next avenue that you have to look at is damages. You can have a great patent that's really being violated, but it's just not generating any damages. And essentially, what we're looking for is a situation where, for the full anticipated budget of litigation, that it has a ratio of the damages have a ratio of at least 10 times that budget, and that's a minimum. The funder is typically going to be looking to get back their capital plus up. If the way these are funded will typically change over time what the return will be. But if it goes all the way through trial, which can be several years, the funder is often going to be looking for as much as their capital back plus 3 times their money, so 4 times their money. And so, if you have a 10 times damages, that means the funder will take 40% of that, so 60-40. And we're, at least at Deminor, we're very cautious to make sure that if things go well, if it gets the damages that we hope, that we want to make very sure that the claimant will get the majority of the damages. You can see situations where if the litigation does not go as well as hoped, if the litigation bombs and the return is very low, the funder may end up taking a higher percentage as a result. And so you can see that that's not terribly different from a contingency situation, right? So a 40% is what a contingency law firm might take. So kind of referencing back to what I was saying earlier, it can be thought of as converting a situation where the law firm doesn't want to work on contingency into a contingency situation. And then the final avenue of the 3 is you just want to look at the parties involved. If you're looking at funding a case that's already been filed, because that does happen, right? Like, it's not unusual that the claimant went in hoping to fund it themselves and realized that they don't have the budget, or they thought that they were going to get an early settlement, and they have a great case, but the counterparty is fighting hard and they don't want to give up the case. They need funding. So sometimes you have a lot of information when the case has already been filed. You know who the judge is. You know who the other side is using for their attorneys. You have a lot of information. So you want to go and you're going to look at the history of the claimant. If they bought the patent somewhere, the history of the inventor. You're going to look at the history, the litigation history of the judge, of the jurisdiction broadly. You're going to look at the litigation style of the defendant, of their counsel. And so you're going to look at all the parties involved. So those are the 3 kind of metrics that you're looking at. You're looking at merits, you're looking at budget to damages ratio, and you're looking at the history of the parties.
Okay. Now, I have a question from the audience, and I'll try and summarize the question. What is the typical profile of a patent case that Deminor would prefer to fund? So in terms of how big the case is, in terms of damages, what potentially how many patents, what type of a plaintiff, are they a competitor in a market, or are they a non-practicing entity, which venues, foreign versus US companies? What's the typical profile that Deminor prefers to fund?
Is there one of those that you would like me to answer first? I'm happy to jump in, but I can answer every single one of those. But
okay.
Is there?
I'll break it down for you. So let's start with. I think you've given us a sense of the size of the case. So let's talk about the number of patents, the size of the damages, generally speaking, involved, and the size of the investment that goes into it.
Okay, in terms of numbers, so Deminor is about $100 million fund, which before I joined Deminor, that sounded like a huge amount of money to me. It turns out that in the litigation funding world, it's a very small amount of money. So we are funding cases on the smaller side. We are typically looking for situations where the law firm wants to do it on partial contingency, or the law firm wants to do costs only. So we tried to fund cases below $4 million in budget, which is very small for patent litigation budget, as everyone here knows. We can go higher, but we're typically going to bring in a co-funder. There are larger litigation funders. With most litigation funders, there are some, you can find publicly traded litigation funders with many billions of dollars in assets under management. They won't really want to look at your case if the budget is south of 10 million, and they absolutely won't look at your case if the budget is south of 5 million. So we're kind of looking in the smaller space, but there are definitely players out there that are looking in the bigger space, and they want to pay all the fees. They want as much as possible because that justifies them getting a bigger return. So for us, typically looking for a little bit of a smaller budget than them. In terms of damages, an absolute minimum is 10 times the full budget. Not 10 times. If we're working with a law firm and the law firm is doing partial contingency, we're going to calculate what part of the budget they're effectively covering, and because we're going to reduce our the percentage of the contingency that we take if they're taking on part of the burden. So we need the damages to be at least 10 times the full budget. And again, the logic for that is what I was saying earlier, is that we want a situation where if this thing really, if the damages are what the claimant and their lawyer have estimated, that they're going to walk away with the bulk of the money. No one feels good when the law firm and the funder are taking half or more than half of the damages. And so we try very hard to avoid that situation.
Now, in terms of the profile of the types of patents that you're typically interested in putting your money behind, are those in a particular technical subject matter? Do they have inventors who tend to be US or foreign, or are you agnostic to the location of the inventors of those patents? Can you talk about what types of subject matter areas you're particularly interested in?
I mean, I would say software is very tough. That's the first thing. Is software is for obvious reasons, right? It's the Alice risk, and so when we see software, we're very diligent. There are many of my many litigation funders just have a blanket no software rule. We don't. We will look at it if it's really if it's really improving the performance of the computer. If there's something that makes it clear that clearly not an Alice risk, then software I think is great. And largely I think you can kind of break patents down into software versus not software. We like not software. It's a little bit more expensive for us because we have to use more outside resources. It's often much harder to understand. I have a colleague in our British office who was a PhD in chemistry. She's a patent litigator. My background is not patent litigation. I did work as an IP attorney, but in the transactional space, and I did litigate, but I didn't litigate in the patent space. So I've had to learn patent litigation as a funder. Whereas my colleague in Britain, she's a British attorney, but she has extensive patent litigation experience, including in the US. So I work with her a lot. And when we have any kind of chemistry-based patents, sure, her background is really helpful. And generally, I think she understands technical things a little better than I do. So definitely, semiconductors, those are hard patents for us to wrap our heads around, but at least you're not looking at such extreme Alice risk. And again, we're a European organization. So it's not U.S. exclusive to us. We like to litigate. There's some real benefits. If you're looking at Germany versus the U.S., there's some real benefits to litigating in Germany. Everyone's quite excited about this UPC, the Unified Patent Court, that's coming online. Although I for one, I'm not sure that it's going to actually be better than just litigating in picking your best European country and litigating there. I think. Again, Germany has a kind of 3-part litigation system where they do damages very last, and you can get they look at infringement, and you can get an injunction in advance of the validity determination. So there's some real benefits, I think, to litigating in Germany. I think that turns out to be very advantageous for the plaintiff, that they can get an injunction very early in the process. So yeah, we don't have a preference for U.S. patents.
I did want to follow up on the preferred venues that you of litigations that you prefer to fund, because here in the U.S. There's usually a choice of going to the district courts to litigate your patents, or in certain special circumstances going to the International Trade Commission and seeking an exclusion order. Now the advantage of district court is you can get actual damages, either in the form of a reasonable royalty, or if your plaintiff is entitled to it, then lost profits. But when it comes to the ITC, typically your only really recourse or relief is some kind of an exclusion order, either a limited or a general exclusion order coupled with a cease and desist order, and there's a bond that the respondents might have to pay if they lose. But there's no actual damages awarded in an ITC case. So the basis of your settlement discussions is different, and really settlement is the only way you get a payout directly from an ITC case. So given those kinds of contexts where some proceedings will not yield a damages award at the end of it, and some that will, and the basis of the settlement discussions are a little bit different, how does Deminor see that? How does the Deminor see the ITC as a forum for funding litigation? I'd also add, ITC cases tend to have a very strict, almost statutorily defined timeline, whereas district court cases can have a variable timeline. So you don't quite know when your recovery is going to come in a district court case as opposed to the ITC. So given all of those factors, how does Deminor assess the viability of funding an ITC case versus a district court case?
I think my answer is gonna parallel kind of your the way you phrased the question. So we would fund an ITC case, absolutely. We look at them, we're interested in them. The question it really is you have to look at the likelihood of the injunction you're going to get and how essential the intellectual property right is to the defendant. If there are many players where if you're going to cut off the U.S. market, that has huge settlement value, and that's fine. If we know going in that the value of this injunction is that it's going to force them to settle, and we feel confident putting a number on that the value of that settlement, and it justifies the budget, then once you're in that situation, the ITC offers lots of benefits, right? It's very fast. So the answer is, you have to look at what you think the value of that injunction is, because exactly, you're not going to get an award, but there's many situations where you can look at that and you go, that party needs that, they're going to settle with you, and so we would fund an ITC case if we were confident of the value of the potential settlement from the injunction.
Now, one feature of an ITC case is typically the complainant has a domestic industry in terms of capital expense, labor, equipment. They actually have a product. They're typically a competitor in a particular market, as opposed to being a secondary patent player or a non-practicing entity. In terms of funding competitor litigation versus funding NPE-driven litigation, do you see a preference in the industry and for Deminor as to what types of plaintiffs or complainants they'd like to fund?
There's definitely a preference for funding if the inventor still holds the patent. That's absolutely going to be the best, because if it's going to end up at trial, especially if it's going to end up in a jury trial, you can put the party that invented it in the stand, and that's great. And we got to feel the same way. That's what we want to ultimately do. So there's strong preference for that. There's not a bar on funding someone that has acquired the patent. If they've acquired the patent, then we're going to look at the quality of the inventor, and we're still fine with that. I mean, the market for patents really accrues to the benefits of the inventors. There's lots of inventors that are being burned and want to monetize their patents but don't want to litigate, and their ability to sell to certain players that are willing to enforce those patents, we view that as a good thing. We think that's a way to benefit the inventor without putting the inventor in a place where they have to litigate. Every other kind of property, if you were to purchase a building and the tenants weren't paying, the fact that you didn't build the building wouldn't prevent you from enforcing against those tenants. So we don't have a problem with that type of situation. We do avoid the kind of really, really trolly troll who's just, they're making patents. The patents were never used for commercial purposes. They're designed for litigation. They didn't even acquire the patent. They built it themselves. And those cases, A, we don't really like that, and it doesn't feel right to us. And B, it tends to do very poorly. So the right thing to do and the most likely to be successful thing to do happen to align in that case. So we will avoid the people who are just bringing nuisance litigation. That's not the way that we're trying to succeed.
And certainly, I think that concern is one that the courts have also considered. I was recently reading news from last week about Chief Judge Connolly in the District of Delaware and his orders about litigation funding and required disclosure. I think his viewpoint is that the public has a right to know who is actually litigating in those courts. So it's an interesting topic. I think it's also starting to get the attention of the court systems themselves. I wanted to raise a potential point of discussion with you, Michael, on making sure that the interests of the funder align with those of the company. So I'm often in situations where I'm representing a company like Expedia, for example, and there is a litigation funder also in the background trying to monetize that litigation. So there are situations I'm sure you can envision where the interests of the lawyer's client and the client's litigation funder don't necessarily align. For example, one party may want to settle and take what's off on the table. Another party may want to take the case to trial. Can you chat a bit about what sorts of dynamics you can possibly see and what the best way is to overcome potential conflicts of interest in those kinds of scenarios?
We always try to make sure that we're funding the claimant directly as opposed to funding the law firm. That's sometimes the law firm has promised the client that they'll never have to deal with a funder, and in those cases we have to figure out how to work with the law firm directly. But we think that always adds a layer of complication. So where we're, because then it's where things get really tricky is when the lawyer and the client have divergent interests, because that's where the lawyer's ethical rules start to get very fuzzy. So where we're funding the claimant directly, that is between us and the claimant. In Europe, outside the U.S., there's a little bit more acceptance of the funder having a little bit more control and having a little bit more veto rights. In the U.S., it's not regulated, but the culture is much more. The funders tend to be much more passive, and so when we're funding here, there's typically not firm consent rights. We can't jump in and say, you can't accept that settlement. We wouldn't contract with the claimant to do that. But if things get really hairy, we can always stop funding, which does give us some control. And that's we would have to claim that there was a materially adverse change, or you can't just stop funding for no reason. But you can see that if that is kind of harking back to one of your earlier questions. While we have a strong preference for the claimant, the good thing about the NPE or the they're dispassionate. They want to be rational, and sometimes the claimant is sometimes too in love with their invention, and they think it's going to make hundreds and hundreds of millions of dollars or billions of dollars, and they're not realistic. And it can be hard for a funder to sit there and watch their funds get burned when a very reasonable settlement is on the table or something like that. And so there's always going to be some right of the funder to say, look, we can't continue to fund this if you're not going to accept a reasonable settlement, or vice versa, right? So we do have there's always something that gives the funder, we can't just put in the millions of dollars and have no ability to stop. But that's typically what we can do is withdraw. And if there's something egregious, then of course we would try to claw back money, but that would be in the case of fraud or something really exceptional. I think most funders have that kind of right. And as far as I'm aware, I've never met a funder that's ever exercised that right. Everyone's interests really are aligned. Everyone wants to make money, and so and to enforce the patent, right? And so a lot these veto rights get discussed a lot, but from what I've heard, they almost essentially never get exercised.
Okay. One quick question for you, Michael, before I wrap things up, which is, do you tend to go out and find folks that could use litigation funding, or do people come with a case to you and say, can you help us funding? How do the meeting of the minds typically happen? How does the magic happen?
Well, there's no single answer. Shirok, I think you're creating an echo. Might you mute? Oh, thank you. Yes. Sorry. So there's no single answer. We form relationships primarily with law firms, although we also reach out to claimants directly through. We've tried using Google Ads. We market the same way as every other business markets, but the best cases tend to come from the law firms. And so we form relationships with law firms, and they are in a situation where either they want to get paid by the hour, and they have a client that doesn't quite have the budget for that, or they want to mitigate the risk and do it on contingency, but share that risk with us. So that's the answer is through law firm relationships primarily, but certainly not exclusively.
Great. Well, thank you so much, Michael, and thank you, Rose, for your wonderful comments. I absolutely enjoyed listening to both of you. I'm happy to open up the discussion to anybody else who wants to jump in. I hope you all enjoyed the discussion here.